the issue of whether the speaker's thing was constitutional or not was decided by the 5, not the 7. And it was still a 5-0. So what they're saying simply, or what they've said simply, is that it is only about cross-carpeting. That once an MP is elected, until he seeks, so practical terms, an MP is elected as an MPP or NDC MP. For the 4 years that he's in Parliament, it's only when he seeks to move to NPP or NDC and continue to be MP. I find that a bit strange. And continue to be MP. That is where he loses his seat. But if he doesn't seek to, and I'm trying hard to find how a person will want to leave MPP to NDC and maintain his seat in Parliament, or leave NDC to MPP and maintain his seat in Parliament. I just want to get that. But what it then means is that, I mean, that's it. They're just saying that the declaration of the intent or pursuing whatever with respect to the subsequent Parliament is doesn't affect anybody. And so it is only when the person seeks to cross carpet. I don't see how we can cross carpet in this Parliament, but well, Nana, I don't know what you
well,
make of this.
I agree 100% with the court's ruling. You see, look at the wording of, and the court dwelt on the wording of the article of the Constitution at issue. It says that the G, it says that if he leaves the party of which he was a member at the time of his election to Parliament, if he leaves to join another party or seeks to remain in Parliament as an independent member, and then H, say if he was elected a member, which is the same. One talks about members, political party. H talks about independent member, but talks about the condition for which their seat can be declared vacant. Now, in my view, and that's what the court also says, the wording of G refers to Parliament. Parliament. Not a political party. It refers to Parliament, events in Parliament, on the floor. And see, as we speak, there have been, if you look at all the cases that members of Parliament had to leave their seats, in 2 of those cases, the case of Professor Wayo Seni and the case of Kofi Asante, they actually cross-carpet. He said, we've resigned, we are no more going to be members of our party. And so that's the end. So that one is clear. There was the case of Tei Nyaunu. You remember Tei Nyaunu? Who also declared that he was going to stand independent in the next election. But he stayed in Parliament. His seat was never declared vacant. I think there's another person who also signaled
in his case, I'm not too sure if it was brought to the attention of the Speaker or if anybody went to court on the matter.
The man actually registered to stand as independent in the next election.
Yes.
Yeah. Oh, you mean nobody formally?
Yes, I'm just saying that it was not.
It hasn't even. They are not even bothered with the next Parliament, because there's also the viewpoint that they have filed to leave their party at the next Parliament, and so not this Parliament. The Supreme Court doesn't. It says that as far as this Parliament is concerned, they haven't crossed carpet. They haven't left their party. They still remain members of their party, as far as the information that we are giving is concerned. They still remain members of their party. And that is only when you say you are leaving your party to another party in Parliament, then your seat will have to be declared vacant, because your constituency.
That's what I want to understand. How does that happen? in this parliament, you know, how can an MP say that I am an NDC MP? I am moving to go and join MPP in the same parliament. How is that possible?
If you move in the parliament to join NDC, you have to go back to your
How do you do that? How do you do that? How can you do that?
By crossing carpet. By announcing that you are leaving the NDC to the NPP side, or vice versa. But if you haven't announced, then you are still sitting with your party. You haven't crossed carpet. As far as the parliament is concerned, you haven't left the party that brought you to parliament.
Okay.
So the ordinary reading of Article G is that it is referring to parliament.
So now let me ask you this. From what you're saying, does it mean that a member of parliament...
For example, let's be practical, because we are talking about a practical situation.
Yes.
Cynthia Morrison. And who are the other people?
The Suhum MP, the NDC MP.
The NDC MP. Have they left their caucus?
In fact, the Suhum MP says that immediately the statement of polls or notice of poll came up, the caucus removed him from the platform.
Has he left his caucus?
How do you leave? How do you leave?
By crossing carpet.
How is that done? I want to understand.
By crossing carpet. By saying that I'm not going to sit with this caucus.
Okay.
I'm going to sit with this caucus. That's what's called crossing carpet.
So once
they haven't moved. They have said that in the next election, we are going to contest we are going to come to parliament as independent. For now, we remain with the caucus. The people of Suhum sent me on the ticket of the NPP. I am still sitting with the NPP caucus. So I haven't changed that mandate.
Now let me ask you a question. Does it therefore mean that a person can be expelled from his party once voted to parliament? A person can be sacked from his party by the party, or a person can resign from his party. But to the extent that he has not communicated his decision to leave his party's caucus in parliament, he remains an MP?
To the extent that he hasn't resigned from his party in parliament.
So despite the fact that the party has sacked him, or he has resigned from the party, to the extent that he has not taken a decision to leave his party side in parliament,
let me tell
he remains in parliament.
Yes, absolutely. That's the wording of the constitution. If he leaves the party of which was a member, the party of which was a member at the time of his election to parliament. So you are elected to parliament as a member of the NPP. If you leave to join another party or seek to remain in parliament, do you know, and I said I was going to tell you something, do you know that even as a parliamentary candidate, once you file with the Electoral Commission and you finish your filing, your party may expel you, but you still be the candidate.
Yes. Yes. No, so Nana, I'm dealing with the practicality of it. So a person gets elected to parliament today. As an MPP member. Today. Tomorrow, the person does things for which reason he's taken through due process or whatever the party's law says and is expelled from the party. We're saying that by this ruling, to the extent that the person has not, by himself or herself, announced that I am leaving my party in parliament to go to another place, the person remains an MP.
In the first place, the people have not been expelled by their parties. In the first place.
I'm just looking at the implications of if we are saying that this is what it means.
Well, but the practical situation that we have on our hands is that the people have not been expelled from their parties. They have also not said they have resigned from their parties.
But their party's constitution tells us that
if Parliament reconvenes next week,
they
will be sitting with their caucus.
Yes. So Nana, the point I'm making to you, see, the point I'm trying to make is that if tomorrow, per this ruling, if we are saying that it is not what happens at the
Outside.
party level, outside
Not what
parliament.
outside.
But what happens in parliament?
Yes.
That's exactly why I'm raising those practical issues.
Yes.
That a person decides to resign from the party.
Okay, I understand. Your issue is practical. It hasn't happened, but it could happen. I think
that is even happening.
One second.
Yes.
By implication, if your party expels you
Yes.
from the party,
Yes.
you still remain a member of parliament.
Yes.
Don't you?
Yes.
Don't you? Because you are in parliament on a mandate, a 4-year mandate,
yes.
which is independent of what happens in your party. So if your party expels you from the party, you are still a member of parliament.
That's just the understanding I want.
Yes.
So whether I resign,
yes,
or so I can be elected today, I put in my resignation tomorrow.
Yeah.
I will remain in parliament for the next 4 years.
Once you haven't left your party in parliament.
Yes.
Yeah.
The party sacks me for whatever anti-party behavior, whatever tomorrow. If I have not taken the decision to leave the party in parliament,
yeah.
I continue
so you are actually insulated or protected as an MP.
Okay.
And that's why I gave you the instance of the Electoral Commission. Once you file, your party gives you, the General Secretary gives you the letter that you are the candidate for Kankwe South. And you file with the Electoral Commission and you finish the filing and you do everything. Your party can expel you, you'll still be there.
Okay. All right. This is very interesting for political parties. And so what about an independent candidate?
Say.
How do we, so let's say
an independent candidate just means he's there on the independent party.
Okay. So let's say in the present case of the independent candidate,
yeah,
he opts to do business with one side. One side. What does that mean?
Oh, it means he will sit with the caucus.
How do we situate that within the context of what that's not cross-carpeting?
No. The independent candidates,
yes,
right from the beginning, wrote a letter to the speaker,
yes,
that I would sit with the caucus. He's still independent. He's still described as an independent member of parliament for so-so. But he says he would do business with the caucus. Same thing happened in I think 2000, if you remember. Was it 2000? Yes, it happened in 1997. And then it also happened in the year 2000. You remember? When in 1997, the CPP members of parliament wrote and said that they will sit with the minority caucus. You remember? And so they were part of the minority group. So the minority group was, I think, 61 NPP and another 5 or so CPP. So there were 65, 66 in number. And then in the year 2000, when the Samia, Nkrumah, and some of the right pocket, they still opted to sit this time with the majority party. You see, so this independent chap, he's saying that for the life of this parliament, he has not left to join the caucus. So it's the same.
All right. Okay.
Now and you see that in terms of the capacity, when you look at the ruling, they give a lot of precedents to justify their capacity. In terms of some of the decisions that they made, they gave extensive precedents. But the minority view, the two judges who disagreed, their main disagreement was that the Supreme Court did not have the capacity, and that they thought that the action should have been taken to the High Court.
That the Supreme Court should have directed the plaintiffs to the High Court.
To the High Court, yeah. The majority gave reasons with precedents why they didn't think so. Now, the minority viewpoint, the two judges, you see, this is a matter of, the way I look at it is that this is a matter of interpretation of a provision of the Constitution. And when it comes to interpretation, the Supreme Court has original jurisdiction. If the suit was that those seats should be declared vacant, if the writ before the court was that those seats should be declared vacant, I'm sure the court would have ruled that to declare a seat vacant, you need to go to the High Court. But the suit was that the constitutional, the Article 97 is the one that has to be interpreted, given a true and proper interpretation. And in that writ, they are asking for an interpretation of a provision of the Constitution. And so the Supreme Court, being the original jurisdiction when it comes to interpretation of the Constitution, they thought they were seized with the capacity. But you see, Randy, even if you went to the High Court, even if you went to the High Court on Article 97G, whatever ruling the High Court gives can be challenged. That this is a constitutional interpretation. In fact, one of the judges made the point that go to the High Court, let the High Court come to the Supreme Court for interpretation. You remember? That you start at the High Court, and the High Court will tell you, okay, this involves an interpretation of G, so go to the Supreme Court. So, in my view, whatever happens, you will still come to an interpretation by the Supreme Court of Article 97(1)G. It will still come back to the Supreme Court because the plaintiffs or any of the parties can say that this involves an interpretation of a provision. And the High Court doesn't have the power to interpret the Constitution. So you have to refer to the Supreme Court.